Sorry, everyone. This is Professor McLaughlin. I thought I was turning up the volume and instead I was forwarding the slides. Um, I want to do a brief lecture on chapter 21, which will be on your exam 3. So please forgive the way my voice sounds and bear with me. It's not going to be a long lecture, but I will have you look at the slides on this video, and also this will serve as a heads up in addition to the exam 3 study guide on what's important to know for the exam. I wanted to initially say something about exam 2. I did not carefully read the questions about the cases, and I felt that in exam 2, particularly the questions about the cases were very obscure and not reflective of what I felt the case stood for and the reason the case was in the book. So there is going to be one case from chapter 21, and I'm going to ask for you to read it carefully. There are some having said that the questions were difficult, you also need to read the cases. I tell you ahead of time what cases you need to read, and if you don't understand them the first time, you can read them again, and you can look for help on the interweb too and Google them. They're all fairly well known, and they're gonna support a particular concept or explain a particular concept. A case that's in the chapter. A case is an application of a legal concept in a dispute, and it requires critical thinking. That is something that you need to develop in this class, and I want to do a better job moving forward guiding you with that. But having said that, I want to make sure everybody's also taking the time to read the case carefully. At least the ones I indicate. You should read them all carefully, but if you're just going to read the cases that are on the exam, read those carefully. So, chapter 21. We regulate sales and lease contracts differently than regular contracts. And this chapter begins a more in-depth discussion of the Uniform Commercial Code, which we've mentioned since chapter 1. It's very important for business. It's very important for domestic business. And then the CISG, which is the contract treaty that's discussed in chapter 21, is very important for international business that's transacted concerning contracts and sales of goods, which is a very particular kind of contract. When you're selling goods, it's something different than providing a service. It's something different than simply a lot of the stuff that happens on the internet, and goods are defined and sales are defined, and the UCC, you should know from your reading, only regulates merchants. So one of the things we want to understand is what's a merchant, and some of the cases will help us understand that. So let's get started. So the Uniform Commercial Code is a uniform law that was developed. The states can adopt it, but do not have to. It applies to the sale of goods. That's the section that we're going to focus on. There are multiple things that the Uniform Commercial Code governs, but for our purposes, this chapter is a broad overview, and we focus on Article 2. Which only applies to the sale of good, but it, as your slide shows, the Uniform Commercial Code applies to leases and secured transactions, and those will be other articles under the code provision. These are the different articles of the Uniform Commercial Code. As I said, we're focusing on 2 and 2A. As you can see, The Uniform Commercial Code gets very detailed. Article 5 covers letters of credit. Article 8, investment securities, and Article 9, secured transactions, which are any transaction that is secured by another asset. So, mortgages, loans that are secured by business inventory. So securing a secured transaction is where something is exchanged. Typically, it's a loan in exchange for collateral or in exchange for the right to possess an asset should non-payment occur. So mortgages are loans secured by title to the house. The bank holds title to the house and repossesses the house if the mortgage is not paid. Car financing is a secured transaction that's secured. The loan has a collateral of the car, title to the car. They can repossess the car. That's the secured. That's the security. That is the underlying collateral for that particular financing arrangement. So let's focus on Article 2 of the UCC. It applies to contracts for the sale of goods. And here you have some of them. You need to understand all these definitions. What is a sale? What is a good? So here I want you to understand that each code will define what the terms within that code mean. So with the penal code of every state, it will define first-degree murder or manslaughter very differently. And that's why in law, it's always best to hesitate and look up before you, unless it's something you absolutely know, because code provisions can define things slightly differently. And in this chapter, we see that there could be a transaction that's mixed goods and services contract. And you saw that in several of the cases there. And what happens, what governs, and so in the case opener, which I want you to look at, what governs a transaction where the contract covers installation of the monopoles for the cell phone reception, as well as physical goods. So goods are sold, but also services are delivered, and that's all part of your contract. And Exhibit 21.2 does a good job of giving you a step-by-step breakdown of the questions to ask when there is a mixed goods and services contract to determine whether the common law, whether case law just applies, or whether the Uniform Commercial Code also applies. And then finally, what is a merchant? And so I want you to take a look at the De Weldon Limited versus McKean case. There was an artist who declared personal bankruptcy. The bankruptcy trustee sold all his assets to a limited company called De Weldon Limited. And the sole shareholder of that company was not the artist, it was somebody else. And the artist, and then ownership of that share transferred to a third entity. So De Weldon Limited has one shareholder, it is not the artist, but the artist did have possession of the paintings that he ultimately sold. And the artist retained legal possession of the paintings, sold those paintings to a bona fide third party who bought them in the ordinary course of business. And the question is, can the sole shareholder of De Weldon Limited stop that transaction or deny that transaction? And I also want you to pay attention to the interesting discussion in the case about if the UCC applies to this case and Felix De Weldon is determined to be a merchant, then the statute of limitations for bringing this action is only 4 years. But if the common law applies, it's 6 years. So that's why we even look at these cases, because if you try and set aside the sale from Felix Dweldon to McKean, it has to be done within 4 years under the UCC. So if the UCC applies and it's past 4 years, you're out of luck for bringing that cause of action. So that's a very interesting case, and that will be on exam 3. So then Article 2A covers the sale of lease, the lease of goods, contracts for the lease of goods. And defining leases, it's the transfer of a right to possession and use of goods for a particular term. So you're leasing goods. You don't want to have a long-term dominion and control over the good. You simply want to pay for the right to possess something over time. So sale and lease contracts, how they're formed under the UCC. This will be reminiscent of our discussion of contracts, offer and acceptance. There needs to be consideration. One of the very interesting things about the Uniform Commercial Code is because it applies to merchants, terms don't have to be specified in the contract. That will not prevent the contract from being held valid by a court under the UCC. So terms can be left open and can be interpreted according to the rules of the UCC, and that will not cause the contract to fail. Very, very interesting. Focus on this. So the UCC has looser standards because merchants are determined to be experts. So the court's not going to declare a contract invalid because it's missing specified and definite terms in the offer. And then finally, what contracts that the UCC applies to fall under the statute of frauds? And that's the contract for a sale of goods. So remember the statute of frauds from Chapter 18, it needs to be in writing. If it's not in writing, it's not valid and not enforceable. So there are exceptions to the statute of frauds under the UCC for specifically manufactured goods. And there might be an admission, a testimony that says, I understand there was a contract. That testimony is an admission by the party trying to deny the existence of the contract, that there was a contract. And that's an exception to the statute of frauds. Hence, the fact that the contract was not in writing will not cause the contract to fail necessarily. So exceptions to the statute of frauds, which requires contracts for the sale of goods of a certain dollar amount to be in writing. So we also remember from Chapter 18 the parole evidence rules. So evidence outside of a written contract is admissible if, and these are the exceptions you need to focus on. I'm running out of time, so I'm going to go a little bit more quickly. And then understanding that courts have a right to interpret sale and lease contracts, and this is how they're going to give evidence priority. The express terms of the contract are going to be most important, and then a final bullet point, uses of trade will be considered, but that's not the most important thing the court will consider. Finally, unconscionability in the context of a UCC is where the contract is extremely one-sided, and so then the court is going to refuse to enforce that. And then finally, contracts for the international sale of goods, the CISG. This is an international agreement. It's a treaty. It must be signed. It governs international business-to-business sales contracts. So it does what the UCC does domestically, the CISG does internationally. It will govern international sales contracts between nations who are signatories to it. So there, I gave you a brief, almost 15-minute lecture on Chapter 21, and good luck on Exam 3.